All right, we're going to go on the record in 2019, CR 10379, State of Texas versus Christopher Caballero.
Welcome to my channel, Gavel in Silence.
So, Mr. Boyd, here's the issue. I referred you to felony drug court, and I see that you say that you can't do it because it's too much to do, but they're recommending inpatient treatment for you. So either you're going into inpatient treatment, or if you don't want to do it, you can be revoked and go to prison.
Well, that wasn't an agreement with the attorney. The attorney, she and I, what I asked the attorney, Miss Christian, I said, well, the police officer that beat me up, I went to the emergency room and I brought it to her attention. I said, well, since I got beat up, and she showed me the police report, the police officer said that I fell from a gazebo.
All right, so here's the thing, Mr. Boyd. I've been a defense attorney, and this is what I always would tell my clients. Sometimes when they would tell me that they've been injured by the police, I would tell them the injury by the police, that may be a separate issue for you to file a civil suit, but that doesn't excuse a possession case. So you're here for possession of a controlled substance, penalty group 1 gram to 4 grams.
No.
According to the plea bargain agreement that you signed up for, they're going to take some items into consideration, which they did, which was an evading, and there's supposed to be a TAP evaluation. The TAP evaluation is a treatment alternative to incarceration program. Basically what that is that someone discusses with you any addictions you have.
Mm-hmm.
And then what ends up happening is based upon the answers that you've given, based upon your history, they make a determination of whether you should do inpatient treatment or outpatient treatment. Their determination was that you do inpatient treatment. I always send people who have drug issues to felony drug court. Well, not always. I'd say like 90% of the time, because it's a good program. You're telling me you do not want felony drug court. I've read your letter where you say you can't do it because it's taking too much time out of your life. So since you don't want to do felony drug court and you refuse that, then the next step for you is for inpatient treatment. So those are your options. You can either do inpatient treatment or you can go to prison. So either way, you're going to be doing time. So do you want to do your time addressing your addiction issues, or do you just want to do your time as an inmate? It's completely up to you.
Well, from my understanding, I mean, my attorney said that I was going to be 5 years probation. She did not say that I was going to go to inpatient treatment.
All right. What do you think probation is?
Staying clean and reporting every month.
And as part of probation, I have to give you conditions so that you will be successful at probation. For example, if you have a drug issue, what would I look like giving you probation and saying, good luck to you, thank you? Probation is more than, here's a sheet of paper saying you're on probation, go live your life and do whatever you want to do. Probation is, you're on probation, you have to report, you have to provide clean UAs, you have to go to inpatient treatment. Those are conditions of probation. So those are your choices, Mr. Boyd. You can, 1, go to inpatient treatment, 2, see if felony drug court will accept you back, or 3, go to prison. Those are your options.
So what if felony court doesn't accept me?
Oh, then you're going to do inpatient treatment or either go to prison.
That's crazy, man. I'm lucky to be alive today because same police officer harassed me twice in 2 weeks, beat me up, and I'm here because of this.
Well, here's the thing. Are you unless you're saying with this case, police officers planted drugs on you, you are still guilty of possession, and those issues have to be addressed.
So does that give them the right to beat me up?
No, it does not. Here's the thing. What I'm trying to explain to you is there are 2 separate issues that you may have. 1 is you're on probation. I've given you conditions. 2, you say the police treated you badly. That's something that you handle on the civil suit. That's not something that you come to me and say, I don't want to go to inpatient treatment because the police officers beat me up. Is there anything else?
That's it. I mean, guess I have to go with the inpatient treatment.
All right. So you can do inpatient treatment, or either I can send you back to felony drug court. What do you wish?
I'll go back to felony drug court.
All right. Ms. Abrams, can you see if felony drug court will accept him back?
Yes.
And that's to happen while in custody. If they say no, then he's to go to inpatient treatment according to the TAP recommendations. All right. Thank you.
Thank you.
Thank you. All right. We're going to go on the record in 2019 CR 10379, State of Texas versus Christopher Caballero. Can our parties announce for the record for the state?
Daniel Escobar for the state of Texas.
Defense.
Ruben Gisana for the defendant.
And are you Mr. Caballero?
Yes.
All right. You're requesting back the following property: a loaded Springfield Armory XD9 9mm handgun with 1 magazine and 12 live rounds, a Sega 7.62 millimeter rifle with 1 magazine and 10 live rounds. And it's the court's understanding that cause number 2019 CR 10379 was dismissed, but it was dismissed because this was a pretrial diversion. Is that correct?
That's our understanding, Judge.
All right. Are both parties ready to proceed, state?
Yes, Judge.
Defense?
Yes, Judge.
All right. State, are you in agreement with the returning of the property?
No, Your Honor, we are opposing returning the property. This was, again, as the court already mentioned, this was a part of the pretrial diversion program. As a policy, our office disapproves returning firearms.
Our policy is
To oppose returning firearms.
All right. Defense?
Your Honor, simply for the fact that the case was, he did resolve his case appropriately. He was successful and the case got dismissed. We don't see any evidentiary value or any reason other than just the desire to take his guns away, necessary in this particular situation. He did buy those guns. They were under his name. He purchased them legally and had no legal reason why he couldn't own guns at the time. They were, seized during the search of his home. However that might have been conducted, but we would just ask that if he could have his, personal property that he, spent money on return to him.
All right. So what is the essence of a pretrial diversion? Is pretrial diversion, you committed the offense, but you are being given the chance to do classes or whatever that's asked of you. And if you complete those, then your case will be dismissed. Is that the crux of pretrial diversion, or is there something else involved?
I'd say that's a good majority of what is required. The only thing is, I think it's just a set term and then some community service hours.
All right.
Your Honor, as you described PDD, that's how I understand it. I do understand that as your job is also to administer, punishment as you see fit or enforce the laws. And in this particular situation, he completed his course, his pretrial diversion successfully. And as far as any further rehabilitation or further punishment, I just don't see his guns, being kept from him, being a problem, since this case was a possession of a controlled substance case. While guns could be
With intent to deliver 4,200 grams,
yes,
which is a first-degree felony.
I would like to mention they weren't on him at the time or anything like that.
Were they at his home?
Yes, Your Honor.
All right. So does anyone have any case law that says the court is required to return these weapons?
No, Your Honor, that's your decision.
All right. Does anyone know if any case law exists?
Off the top of my head, I'd say no, Judge. I'm not aware.
All right. So if you all would like to have a chance before I make my ruling to see if their case law, I'm not aware of case law that says if someone completes a pretrial diversion, that the weapons that were seized are supposed to be returned. I can understand, and there will be no issue with the court if the case were dismissed, or if there was a jury trial and he were found not guilty, then I could understand. But pretrial diversion, even though it's pretrial diversion, it's really sort of a form of probation without the overview of the court, because you still have conditions to do. And if you complete those conditions, then the case will be dismissed. As opposed to, say, for example, if the search warrant were a bad search warrant or were an illegal search warrant and the state dismissed it, then the court can understand automatically you should get your items back. So if you all would like to come back on, let me give you all a date. If y'all will come back on the 20th, I will make a decision on whether or not to return the weapons. And if you all have any case law for me during that time, I'll review it.
Yes, Your Honor. Would you like that you filed as a memorandum?
Oh, you can email it to, I know how it is to do memorandums of law. I've been a defense attorney before. It's like, Judge, can I just hand you the case law? No, if you just have case law and the state has my email, and I know your office has my email too, you can just send it to me, the case law you have by email, and I will review it. Just make sure you include the state in that email.
Absolutely. I appreciate it.
All right. And then, sir, you can attend the hearing if you want to in person or by Zoom.
Okay.
All right.
And I was wondering, does that mean that I can't also purchase guns in the future, or because since I'm not, or since you're deciding if I could get these or not?
Well, here's your issue that you're looking at, and you'll need to speak to an attorney. The issue that you're looking at is that you were placed on pretrial diversion, and whether or not you're allowed to purchase guns or whatever will depend on what the implication is of your pretrial diversion. All right, so I'll see you all back on Monday.
Thank you.
Thank you. And counsel, if you don't have my email, the state will be able to give it to you.
We're not hearing it.
No, the 20th. I know I said money, but it's Tuesday, the 20th. Thanks.
This isn't a conversation anymore. When a judge starts listing options like this, the decision is already moving forward, and every path comes with a price no one wants to pay. The court draws a hard line here. Alleged police misconduct may belong in a civil lawsuit, but it does nothing to erase a drug possession charge sitting right in front of the bench. Turning down felony drug court isn't just about time or inconvenience to a judge. It sounds like rejecting help, and once that happens, the system stops offering choices and starts enforcing consequences. Probation isn't freedom with paperwork. It's structured control, constant monitoring, and mandatory treatment, especially when addiction is already part of the story. The defendant speaks from pain and frustration, but the court operates in categories. One issue belongs in civil court. The other decides whether you walk out free or walk into custody. Pretrial diversion may dismiss the case, but it doesn't declare innocence, and it's in this legal gray area that Judge Boyd slows down, knowing this ruling reaches far beyond one defendant.